All right, it's 3:30, which I think is the appropriate time for us to start. Thank you to everyone for being here to talk about copyright with us. This is a really important time in the world of copyright here in New Zealand. And I hope you find this webinar helpful and useful. And I thank you all for joining us. Let me see if I can figure out how to move along to the next slide now. So the Copyright Act of 1994, for anyone who doesn't know, is under review. The Copyright Act was actually updated in 2008, but the last sort of full big review was 1994. Someone, could you maybe mute yourself?
Yes, you're going with computer audio.
Thank you. So we have until April 5th to put together. There you go, thank you. So we have until April 5th to put together submissions, and the LIANZA Standing Committee on Copyright is working really hard to put together a submission that represents the needs of the library profession here in New Zealand. In order to do that, we need to hear from you, and we need to have an opportunity to engage with you on what you want to see in the Act and what's important for you in your day-to-day work. And that's the purpose of these webinars, is to make sure that everyone has the skill set that they need to contribute and feels that they have an opportunity to present and understands what it is we need to hear from you and what's important. So for anyone who doesn't know me, hi, I'm Mandy. I run an organization called Toihautū. That's the Maori word for sharing. Among other things, we look after the Creative Commons licenses here in New Zealand, and we look after what goes on with copyright here in New Zealand. I've been a librarian for 20 years. Copyright came into my life very early in my career, and I've not quite managed to step away from it yet. And at this point, I don't think I'm going to. Kim, would you like to introduce yourself?
Hello. Kia ora koutou. My name's Kim Gutchler. I work at the National Library of New Zealand, where I look after the published collections. So I get to spend quite a bit of my time looking at the relationship of the National Library Act to the Copyright Act, and it is quite a tricky relationship. And I've been a member of the LIANZA Standing Committee on Copyright for a number of years. So yeah, welcome to the webinar.
Thank you. So we're going to work on covering the basics today. What's really important to us is that everyone in the library profession is starting from a basis of understanding. And we know that there are people in the profession who know almost nothing about copyright. Maybe you're new to the profession, maybe copyright isn't something that's been part of your work before. And we want to make sure that you have a firm enough understanding of the basics to contribute in a meaningful way. So that's really what we're going to go over today. We're also going to go over the library exceptions, which is an important part of the copyright basics for those of us who work in libraries and who work with libraries. And then we're going to talk a little bit about the review and how you can participate in the review and contribute to the review. For those of you who are copyright experts, don't worry. We have future webinars where things will get a little bit more exciting. So we have fair use, fair dealing, and safe harbor for GLAMs coming up on the 7th of March. And that will also be done by the LIANZA Standing Committee on Copyright. I'm not quite sure which of us is doing it. And then we'll be doing one on NAS, digitization, and orphan works. Orphan works are an enormous issue for libraries. And we're going to be talking about those on the 14th of March. They're free. It's fairly easy to join. Zoom is, easy enough to download. So if you can, please make time in your schedule to join us for those, to make sure that you have an opportunity to hear our thoughts and that we have an opportunity to hear from you. So this is going to be quite possibly the fastest copyright basics presentation in the world. If you sort of have questions, if you get to the point where you're like, wait, I don't understand what she's talking about, you can send me an email. My email is easy to find on the website. It's mandy@toihautū.nz, so Tohatōha, just .nz. And I'm more than happy to work with you one-on-one if you have questions, to make sure that you feel that you understand and can participate effectively in the review process, because that's what we want. So, copyright. Copyright protects a thing called original expressions. Original expressions can be a whole bunch of different things. in sort of the parlance of the Copyright Act, literary works. But literary works aren't necessarily novels, though novels are definitely literary works. They're also software and data compilation. In a lot of ways, you can think of literary works as things that you write down. So letters, numbers, those sorts of things. Textual works. Dramatic works. So copyright protects choreography. So if you have a dance perhaps that you've put together, or if you have a mime set that you've put together, copyright protects those as dramatic works. Artistic works, plumbing. So plumbing, fashion, building plans are all examples of artistic works under the Copyright Act. You might think of artistic works as sort of visual art, things that you draw generally qualify as artistic works. Music, arrangements, the ways in which you write down sort of musical notation. Sound recording, so when you make a recording, such as this one that is happening right now, that draws copyright protection. So all of the sounds that you record.
Because I just suddenly thought about something I did with my
Is someone asking a question? I can sort of hear someone talking. Films, so we all know what a video is, and those are protected under copyright law.
This whole thing is just like...
We also have something called communication works. Communication works are things that go out over the airwaves or over the internet. So TV, radio, podcasts, those sorts of things qualify as communication works. And then typographical arrangements. I don't know if you guys have had the opportunity to see those really cool tote bags where they'll take a public domain work. So for example, Pride and Prejudice, and lay it out really neatly on a tote bag.
So it's not important now.
That's an example of a typographical arrangement. Those are only protected for 25 years. So in terms of what does copyright protect, this is sort of the big high-level answer to that. Copyright exists for a lot of different reasons, and depending on who you ask, you're going to get a different answer. What I've tried to do here is to sort of distill the range of answers that you're going to see to that question. And then in a minute, we'll look at MB's answer to that question. So copyright exists at its base to encourage the creation of new works, right? It is in everyone's best interest if we have sort of a vibrant literary scene, a vibrant musical scene, a vibrant dramatic scene. We want people to be creating new works. And the way in which we typically encourage that is to make sure creators can make a living. I don't think that there's anyone who works in copyright who doesn't think that it's crucially important that people who want to are able to make a living from the works that they create. And then to protect the integrity of a creator's work. Here in New Zealand, copyright actually comes in two different bundles of rights. There's the economic rights, and that's what we mostly think about and talk about with copyright. But there's also something called moral rights, and the moral rights protect the integrity of a work and protect the sort of creator's right to be identified as the person who created it, the right not to have a work that they didn't create attributed to them. Moral rights are really sort of outside the scope of what we're going to be talking about today, but if you do want to talk about moral rights, shoot me an email. I'm always happy to chat about moral rights. So MB's issues paper, one of the things that they've done that's particularly interesting is they have laid out some new objectives. One of the ways that New Zealand's Copyright Act is different, and maybe not in a very good way from other copyright acts around the world, is that it doesn't have any objectives. It's very important to have objectives in the law so that judges and people sort of making legal decisions around the act have some sort of guidance from Parliament. So these are the proposed objectives. Hopefully you can all see them on your screen. And this is something that's really important for us as a profession to talk about. What do we want the objectives of copyright law to be? Here's a list from MB. There are other sorts of lists, and there are other sorts of ways that we could talk about what do we want to prioritize here, etc. So this is going to be an important part of the copyright reform process, is identifying what these objectives are, and then helping MB to understand what we think is important in them. Copyright is very restrictive in some really important and interesting ways. It's automatic. It's fairly common that people think that perhaps there's a registry that they have to sign up for. There's not. As soon as you make a doodle on a page, you have created a copyrightable work. You don't have to do anything to draw that copyright protection. Copyright applies on the internet. Sometimes people think that the internet has different rules where copyright doesn't exist, and that's very much not a thing. Copyright applies on the internet just as much as it does in the physical world. You don't have to put the little C there. There have been times and places in the world where you did have to put that little C there, and we're not in one of them. So the little C is a nice reminder, but it is not the thing that is actually important. Not only can copyright be owned by your employer, but for those of us who have jobs, it almost certainly is. So the work that we do in the course of our employment is very much likely to be actually owned by our employer. It's worth considering and sort of thinking about when you're doing your own work, what are the bounds of this for you? And making sure that your side gigs are cleared with your employer so that there aren't any conflicts there. It can be assigned by contract. If you've ever hired a photographer, you might have gone through this process where sometimes photographers will price differently if you want the rights. That's very common. So you can assign by contract who owns it. That's how licenses work, and it's how the publishing industry works. Copyright covers the expression, not the idea. And this is a very jargony way of saying that you have to actually make a thing to protect it under copyright law. So it is not uncommon for me to get emails from people who have come up with brilliant new business plans and they have an idea for it and they want to figure out how to protect it using copyright. And the fact is, this copyright can only exist a thing that you have actually made. You have to have actually created the thing in order to draw copyright protection. And it lasts for 50 years after death, most of the time with some nuances. And it's important to realize, because a lot of times when we talk about copyright law, we'll say it lasts for 50 years without always reminding ourselves that that's 50 years after the death of the author, which is really quite a long time. And there are some nuances in there and some other sorts of photographs. There's some different things in there that can have different periods, but 50 years is a good rule of thumb. There are a whole bunch of things that copyright is not. Copyright is not a patent. If you have invented a fabulous new widget and you want to go make your millions on your fabulous new widget, what you need is a patent. Copyright law is not going to be able to help you on that. Trademarks. Trademarks are copyrightable, but they're actually an entirely different area of law that we're certainly not going to talk about today and that aren't going to be part of the Copyright Act review. They're not a replacement for a government response to WA 262. The Copyright Review Issues paper discusses this a little bit, but the government is going to need to respond to 262 in a way that goes beyond the Copyright Act. Copyright doesn't cover everything. So Tonga is often aged out of copyright or otherwise unprotected. The public domain. I think that the public domain is an enormously important, rich resource for all of us, and that includes things that either were never covered by copyright because they were created before copyright existed, or they're things whose copyrights have expired. So those aren't covered by copyright anymore. And facts. Facts aren't protected by copyright. So 2 + 2, that's a fact. You cannot copyright that. What you could do, though, is you could take a whole bunch of different math problems, apply some pedagogical thinking to lay them out in a particular way on a page as a worksheet, and then you could protect that. But the actual math problems themselves aren't protectable. This gets a little bit interesting when you get into things like algorithms and other sorts of complex computer things, but they're not really things that we work with every day in most libraries. Ideas. We already went over this. You have to actually make the thing in order to protect the thing through copyright. And data. So a few minutes ago, when I said facts are not protected by copyright law, that gets a little bit complicated when you're looking at data. Data and copyright are complicated. The simple way of thinking about it is to remember that a single data point is generally a fact and can't be protected under copyright law. But a compilation of data laid out in a particular way certainly can and does draw copyright protection. Copyright has exceptions, and Kim is going to talk about those. Kim?
Right, okay, thanks, Mandy. Yeah, so the Copyright Act 1994 has a number of exceptions for libraries. It also has exceptions for educational purposes, but I'm sorry, we don't think we've got time to cover those today. So the library exceptions, who can copy? Can you move my slide along, Mandy? Slide?
Done?
Cool, right. The first thing to talk about is who can use the exceptions for libraries, and the Act says they can be used by librarians at what the Act terms prescribed libraries. So a prescribed library is defined in section 50 of the Act and in the Copyright General Matters Regulations 1995. You can find both of those on the New Zealand legislation website. So the prescribed libraries include the National Library, the Parliamentary Library, the District Law Society libraries, all the libraries of government departments, local authorities, Crown entities and educational establishments, so that's schools, universities, wānanga, polytechnic. Also included are all libraries who are members of the interloan scheme. So if you're trying to work out whether you're a prescribed library or not, the general rule of thumb is that they are libraries that are not conducted for profit. So let's go on and talk about the library exceptions. These live in sections, you can see there, 51 to 56C, 79 and 226D. So basically the exceptions can be grouped under 4 headings. It's about making copies, it's about, so these can be both for individuals or for the collections of other libraries. They can be about circumventing technological protection measures on behalf of users. They're about renting works, and they're about communicating digital copies. So I'm going to talk about each one of these in turn, and we'll start with the most important one, which is making copies. So the copying that librarians of prescribed libraries can do for their users and for the users of other prescribed libraries must be for the purposes of that user's research or private study. So there are a whole set of conditions that apply to supplying a copy for research or private study. And they are that there must have been a user request, so the user must have asked for a copy. That no one person is supplied at the same time with more than one copy. That any charge made for the copy is no more than what it costs to make the copy and a reasonable contribution to the general expenses of the library, so it can't be a profit-making thing. That the person being supplied with the copy may only use it for the purposes of their research or private study, but it's important to note that the librarian isn't required to determine if that is how the copy has been used or is being used. The copy that the librarian can supply can be a digital copy, but then the librarian must destroy any additional copies that they're made. So sorry, but this means that as librarians, we can't scan copies of articles, save them to fill any requests that we may receive for that article later. Also, if you supply a digital copy, it needs to be accompanied by a written notice that sets out the terms of use of that copy, which basically means that it makes it clear it's for the recipient's research and private study. Slide, please, Mandy. Yeah. What can be supplied as a copy for research and private study can be a little bit tricky to determine. The Act talks about reasonable proportion, but then very helpfully doesn't define that. People often think there's a 10% rule. Well, it's really, really important to know that there isn't a 10% rule. So you have to think about reasonable proportion yourself. And when you do that, it's really useful to consider the amount and the substantiality of what you are copying in relation to the whole work. So for example, if you copied the whole of a short story from a collection of short stories, you'd be copying the whole work, as each story itself is a complete work. When you want to think about reasonable proportion, think about if what you want to copy captures the kind of pith or the essence of the work. If you can look at something and think, yeah, I've kind of taken the guts of it, well, actually, it's likely that you've been taken what would be considered more than a reasonable proportion of the work. The Act's a little clearer about copying from periodicals. So you can supply a user with a copy of one article from an issue of a periodical, and you can supply them with more than one article from the same issue when they, quote, relate to the same subject matter. This can be quite simple to determine if you've got a general magazine, but it's much more difficult for specialist magazines when all the articles are about the same general subject. So for a specialist journal, the same subject matter will need to be quite specific to apply to do more than one article there. Okay, the librarian of, so we'll now move on to talking about copying for the collection of another prescribed library. So this is sections 54 and 56C. So as the librarian of a prescribed library, you can copy an entire work for the collections of other prescribed library when certain conditions are met. It's really, really important to note that this exception only applies to books, so not to periodicals, music scores, or other types of work. But it does allow for you to copy and supply to a library an entire out-of-print book. There are some conditions that have to be in place before you can use this exception. So the library that will be receiving the copy has to have not been able to obtain, get a copy at an ordinary commercial price for the preceding 6 months. They have to keep records about what has been copied, and if the copyright owner turns up and says they want to look at those records, they have to allow them to inspect those records. And if the copyright owner requests it, then they must have to pay them a sort of equitable remuneration for the work that has been copied. The library that is requesting the copy, so if your library wants a copy of a book and you've tried to get it and you can't, and you've found another library who's got it and is prepared to copy for you, you have to tell that library in writing that those conditions have been met. It doesn't say so in the Act, but it is really recommended practice that for print copies, that a sticker or stamp be placed on the copy saying this copy has been made in accordance with the provisions of section 54 of the Copyright Act 1994, and that just keeps it really clear and everyone knows that you have done it lawfully. You can supply a digital copy as well, and where that's done, you've got to destroy any additional copies created in the process. There's also copying for preservation or replacement, which you can do for preservation or replacement in your own collection and for replacement for the collection of another prescribed library. So if you're a prescribed library, you can copy any item in your own collection for the purpose of preservation or replacement. The condition here is that it isn't reasonably practicable to purchase a copy of the item in question. It's a bit interesting what reasonably practicable is, but you would, really have to have tried and failed or know it's out of print or something. So where you make a copy that's in a physical format, the copy can be added to the library's collection in addition or in place of the original item. If you make a digital copy, where you can do it if the original item is at risk of loss, damage or destruction, and it's not reasonably practical to purchase a copy of the original item, the digital copy has to replace the original one. So unlike the physical one, which can be an addition, the digital copy has to replace it. The Act says that the original item must not be accessible by members of the public except where the nature of the research they are undertaking requires or may benefit from access to the original item. So you don't have to get rid of the original item, but you've got to basically withdraw it from public access unless it is vital for the research purposes that someone could see that original item. The librarian of a prescribed library can supply to other libraries, but only to replace an item in the collection where it's been lost, damaged or destroyed. So the item can't be added in addition to the original item. Again, you can provide a digital copy. Again, the condition is that it's not reasonably practicable to purchase a copy of the original item. And again, for print copies, it's recommended that a sticker or stamp be placed on the copy stating this copy's been made in accordance with the provisions of section 55 of the Copyright Act 1994.
Kim, I've just got a question.
Yeah.
Is there any work specification in section 55? Like, does it specify what types of work the preservation or replacement is talking about?
As in?
Well, the previous exception you talked about was book specific and not.
No,
this is wider.
This is any item. Yeah, no, this is wider. I'm pretty sure it is. Yeah.
Thank you.
Let me just nip into section 55 and check that before I go online and saying that's for sure, but I'm pretty sure it is.
I believe it is too.
Yep, any item in the collection Yeah. Yeah, it's any item. It's really weird that the other one is just limited to books. It's a very strange kind of bit of wording in the Act.
Great, thank you.
And again, if you're making a digital copy, you must destroy any additional copies that you've created in the process of making that digital copy. So, Section 56 of the Act talks about the librarian of a prescribed library being able to supply a copy of an unpublished work from their collections to any person for the purposes of research or private study. So all the copying we've been talking about up till now has been of published works. So this copy can be a print copy or a digital copy. The same conditions that we talked about for the published copy supply apply here. So 1 copy per user, user request, payment only being the cost of production plus that contribution to expenses. Again, if you supply a digital copy, you have to supply a written notice stating it's for the person's research or private study. And again, you have to get rid of any digital copies you make on the way to making the digital copy you supply. The key difference between the supply of copies we've talked about up till now and this one for unpublished is that you can supply a copy of the entire unpublished work rather than just a reasonable proportion. There's one caveat for this exception, which is if the copyright owner has prohibited copying of the work, which will usually be in some sort of donor agreement or something, and the librarian is aware of that or should have been aware of that at the time they make the copy, well, they can't make the copy. So that's the one circumstance under which you can't use this exception. Renting of works. So educational institutions and prescribed libraries can offer computer programs, sound recordings and films for rent under certain conditions, and the conditions really are that it's you're not making a profit and that the work has to have been put into circulation with the license of the copyright owner. While we're just talking about rental things, it's worth noting that the lending of printed works such as books and periodicals is not an infringing act in the Copyright Act, thank goodness, because that's the core of what we do. So libraries, if they wish, can actually make a rental for that, and many libraries do to help cover costs. But again, no profit making, please. Mandy talked a little bit about communication and communicating works before. So Section 56A permits librarians of prescribed libraries to communicate, that is to transmit or make available via means of a communication technology, a digital copy of a work to an authenticated user of that library. So that's someone who's allowed to use the library and goes through some authentication system to prove that they are who they are and they've got a legitimate use to use the library. I haven't dealt with all the conditions of this because there are quite a few conditions to using this exception. So if you need to use it, I suggest you read Section 56A kind of carefully before doing it. Happily for us, many of the in-copyright digital works that libraries provide to users these days are provided via subscription license agreements with publishers and content aggregators. So your EPIC subscription agreements would be an example of this, and those publishers and content aggregators have dealt with the copyright stuff. So this reduces our need to use 56A and to tangle with all the conditions. So that's kind of nice, but it's nice to know it's there if you need it. Section 226D, jumping well on into the Act, permits the librarians of prescribed libraries to circumvent a technological protection measure on behalf of a user to exercise an act which is permitted under the Copyright Act. Now, there's quite a bit of process to using this one. So for a librarian of a prescribed library to be able to do this, the user has to have been prevented from using the work by the TPM. They have to have requested help from the copyright owner or licensee and either have not received a response to their request or have been refused assistance. They have to have asked the librarian for help. The librarian has to confirm that what the user wants to do is
Kim, are you still there? I seem to have lost Kim. Has anyone else lost Kim?
Yes.
Oh,
Ah, are you back now, Kim?
I'm back.
Yeah.
You all switched off because it gets so complex on TPMs.
Here we go. Give me a moment to get us back. There we are. Continue.
Shall I start TPMs again? Yes,
Sure.
maybe. Okay.
Yes, please.
So as a librarian of a prescribed library, you can circumvent a technological protection measure on behalf of a user to exercise an act which is permitted under the Copyright Act. So as I was saying, there's an awful lot of process to this one. So for you to be able to use this exemption, the user has to have been prevented from using the work by a technological protection measure on it. They have to have requested help from the copyright owner or licensee and either have not received a response to their request within a reasonable time or have been refused assistance. The user has to ask the librarian as a qualified person for help. The librarian has to confirm that what the user wants to do is actually a permitted act under the Copyright Act, and confirm that the user has sought the help of the copyright owner and been refused or not received a response to their request. Then the librarian has to make a declaration in the form required to the supplier of the TPM circumvention device. So you have to nip off to the Copyright General Matters Regulations, which I talked about before, Section 5C, and see what you have to do there. So it's quite a lot of process to follow. I think this is an important kind of area that we have some abilities in, and it's probably one that I certainly would like to encourage LIANZA to make some comment on in the review in terms of making this a little easier, because it's quite heavy going to use this exemption. So on to communicating digital copies. Oh, have we done digital copies already?
I think we've done digital
We
copies.
have, we've done digital copies. Okay, so that's been a really quick look at the exceptions for libraries in the Copyright Act. The link up here is to the guide that LIANZA wrote, edited by Tony Millett quite some years ago, but because the Act hasn't been revised, it's still absolutely the best advice on this. There's a lot more detail about all the exceptions and the implications of the Act for librarians there. The LIANZA Standing Committee is really happy to take specific questions and write those up and to share them with the library community, because sometimes the question that you have specifically is something that other people think, yeah, I'm really interested in the answer to that too. So we would try to make those available to people. So this is the email address to write to ask any of those questions. So now I'm going to hand back to Mandy, who's going to talk to you about copyright reform.
Excellent. So, copyright reform. Copyright reform is limited in some really important ways. And in order for us to effectively both talk about it and then effectively report back to MD as LIANZA, I just want to make sure that we sort of all have a basic understanding of what the sort of framework of the process is going to be and what the limitations are that we're going to be operating under. And the big one, of course, is our international treaty obligations. The Berne Convention, TRIPS, the Universal Convention on Copyright, and the CTPP all in important ways limit what we're able to do here in New Zealand with our Copyright Act. We're not able to completely reinvent the wheel and create something new. We have to operate within the frameworks that we've agreed to internationally. And there are really good, important reasons for this. We live in a global world, and we need to be able to rely on Australia's protections and protections in the United States and protections in Europe and Singapore and South Africa and China and around the world, that we all have sort of a coherent shared understanding of copyright. And while the differences, there can be differences, we all need to have sort of the same baseline. And that's what those international treaty obligations do, is they ensure that we're all operating from roughly the same place. There's still a lot of room for us to make transitions and be innovative and make things better, but the basic framework is really already laid out there for us. Copyright is hotly contested. I don't know how many of you paid attention to what happened in Australia. The fact of the matter is that there are a lot of interests, many of whom have an enormous amount of money, around copyright. So if you think about the motion picture industry, the music industry, the book industry. There's a lot of money in this, and the library part of it is actually fairly small compared to the larger whole. So it's important to realize that things are going to be contested. Hopefully everything will be nice and civil, but it's good. It's a good, healthy debate for a democracy to have. It's going to be a long process. So as far as I can recall, this process has been going on for about 2 years now. I would expect it to continue for another few years. My guess is that ultimately, by the time we're at the end of the process, it will have taken 6 to 8 years. It's a big law. There are a lot of consultations that have to be done. So we're in this for the long haul. And it's vitally important to the future of libraries here in Aotearoa, New Zealand. What our Copyright Act looks like is going to frame the kinds of new services that we can develop, new ways in which we can interact with our patrons, ways in which we interact with our collections and what we can do with our collections. And it's really important that we work hard to ensure that we have an act that both meets our needs right now, which I don't think the current act does, but is the kind of act that can be forward-thinking. So we want an act that is as technologically neutral as possible, so that what we can do in the future isn't prescribed by the act simply because a new kind of thing was invented. So it's important. It's going to take a long time. It's hotly contested, but there are lots of different ways for you to be involved. The copyright community here in New Zealand has really come together to work hard to ensure that everyone has an opportunity to participate. MB are offering workshops around the country. We'll send these slides out to everyone so you can click on the links. Many of those workshops still have openings in them. Sarah Powell from AUT, she's a copyright officer there, and Victoria Leachman from Tapapa have gotten together to do some really nice workshops where they're going to walk you through sort of how to put together a submission and talk about some important details. It's going to be much more detailed than today, and I think really valuable. LIANZA's Standing Committee on Copyright is going to continue to offer workshops through March on more detailed parts of the Act to help to make sure that you have an understanding of what you need to know in order to meet the April deadline for MB. And then Toihautū is going to have a February 11th workshop here in Auckland to talk about what we want in a Copyright Act, and we'll have other opportunities as well for engagement. At this point, what's really important is that you get a chance to tell your story and that you get to talk about how copyright either makes your job harder or makes your job easier, or ideas that you have for things that you would love to be able to do, but you can't do because they're prescribed under the Act. So that's what we're really looking for, is you to engage with us, tell us your stories, so that we can, as much as possible, communicate back to MB what's important for the library sector, because the library sector is super important. And that is our last slide. I think we probably have time for questions. Should we do questions?
Yeah.
Excellent. Who
Not
has a
guaranteeing
question?
we can answer them all, but definitely.
No one?
I'll start. So Victoria from Te Papa. I'm looking at Te Papa's submission in terms of expanding the library's exceptions to include museums. Right at the moment, of course, museums aren't included in those exceptions, and consequently we can't even take advantage of the small sliver of exceptions that libraries have at their disposal. I'm actually thinking about recommending that some of these exceptions be work not limited by the type of work or whether the work is published or unpublished, mainly because of course with our material we mostly, especially in the preservation side of things, we take copies to help preserve it, the physical item, and also take copies to create a digital surrogate to help with preservation purposes. My question is, in terms of your unpublished material in a library, how useful are the exceptions currently to you?
They're not that unuseful actually, because the copying is the whole work. Probably the tricky issue for us is donor conditions, because most of the unpublished collections come in from donors. And so for us, that's probably partly an internal problem. It's about recording those donor conditions and making sure they're visible to users and visible to library staff. But I mean, if there, as I was discussing before, if there isn't a restriction by the copyright owner on copying it, the copying that we can supply for people's research and private study or is actually quite good. But it's the trouble when there's restrictions on it. Yeah.
Okay, that's good to know. Thank you.
So we had a question come through chat. Sarah Powell asked, can you please explain what a prescribed library is? Kim, do you want to take that one?
Okay.
Or do you want me just to go to the Act?
Well, I can repeat what I said, which is prescribed libraries are actually defined in the Act in section 50 and in the Copyright General Matters regulations. So I gave a list of them, which is, so starting with the overall rule of thumb, which is that they are libraries conducted not for profit. Now, that doesn't mean that the library of a profit-making organisation necessarily is a non-prescribed library, because the library itself may not be conducted for profit. So basically, you've got National Library, Parliamentary Library, District Law Society libraries, all the libraries of government departments, local authorities, so all your public libraries, Crown entities, and all the libraries of educational establishments, so that's schools, wānanga, university, polytechnics, and libraries that are members of the Interloan scheme. Yeah, so hopefully that answers your question, Sarah. But as I say, the general rule of thumb is the library is not conducted for profit.
All right. Does anyone else have any other questions or comments? We were aiming for 45 minutes, so I think we have achieved that. Give one more moment, see if anyone wants to ask anything.
Just thinking about, you know, some of the stories that we need to tell. So say, for example, when I talked about our ability to circumvent technological protection measures on behalf of users, when we did a survey of the New Zealand library community, the LIANZA Standing Committee did 2 or 3 years ago, we got quite a bit of evidence that people had used the technological protection measure exemption. And I would be really interested if some people would share stories about using that, because I mean, when I was preparing the webinar and I actually looked into the detail, because I've never had to use it, as to what you had to do, I thought, jeepers creepers, does anyone ever use this exemption? It's so painful. And it would be good to know, because I mean, it doesn't take account of the fact of what if you can't figure out who the copyright owner is. You know, it says you've got to try and have contacted them and either not had a response, but there's a lot in there that just is much vaguer in terms of how life works. And I think it would be good to hear some stories of how that has worked in practice.
So Tracy Thomas in the chat says that some law firm libraries were eligible to be prescribed, but only if they complied with the interloan scheme, which meant that they then had to upload their holdings into TPMS and start supplying copies. And some have chosen not to do that and so are no longer prescribed libraries. I would imagine that there might be some other organizations, perhaps media organization libraries, that might also fall into that category, where they're a non-prescribed library for either competitive reasons, so they dropped out of ILL or whatever.
Yeah.
And Catherine asks, are we likely to see changes to New Zealand copyright law this year? And I think Marrakesh, is it only Marrakesh related changes, or are there other changes?
There's another one coming along too. I think Marrakesh is the one that's probably going to be the one that's passed this year, but they've also, the Trade Department Ministry have actually agreed to the performers, the performing sections as well. So I don't know whether, I mean, they've asked that question in the Copyright Act review about
performers' rights. Yeah, they are coming.
Performers and their performances, but it's a moot point because they've already agreed to it under a trade agreement. So it's like, well, I feel like typing, well, why are you asking this? There's no point, you've already done that.
Yes.
Yeah, but I don't know whether or not that's going to come through. But that's definitely the next, after Marrakesh, I think it's the next one on the cards. Whether they get that through to this year is a bit debatable.
For those of you who aren't copyright geeks and don't know what we mean when we're all like Marrakesh, the Marrakesh Treaty has to do with ensuring that people with print disabilities, that there are exceptions for people with print disabilities to make copies as needed to make works accessible for that community. So that's what Marrakesh is. It's another one of those international treaties.
Mm.
So Tom asks, have any libraries in New Zealand been fined for breaking copyright, and is there case law? So one thing to know is that mostly there aren't fines as part of it. The way that it works is that a copyright owner would generally come up, or a collecting society, someone would come up and say, hey, you've done something you shouldn't, and then things would get sort of worked out. Has anyone talked at all, like what sort of case law has happened recently that might be of interest to this group, Kim, other than the 2015 University of Auckland case was sort of the big one that
That's the big one I'm thinking of, yeah.
Yeah, New Zealand is not a particularly litigious place, so there doesn't tend to be a lot of traffic through the copyright tribunal. Someone says that they know of a private engineering firm library that got in trouble with Standards New Zealand, which seems fairly likely. And some institutions haven't paid for CCL licenses, but I don't know how much of that actually goes through the court system versus is worked out between the copyright owner and the library individually. One of the challenges that we actually face here in New Zealand is that there isn't a lot of case law for us to rely on.
Yeah, I think one of the things, and this is something we would want to comment on in the response to the issues paper, is that probably there isn't a lot of case law because libraries and which are often part of government institutions are very risk averse. So we tend to, uncertainties in the law or the risk of something happening, even if it's really small, like around some of the orphan works things, tends to stop us from pushing out and doing that, even though there's very low risk. So I think we need to talk about that kind of chilling effect that uncertain or legislation like that can have, where actually the risk is really low, and there should be, the legislation should look to support libraries in taking some of those risks, I think,
Yeah, and I think liability limitations can be really beneficial. So if you're looking for policy solutions for libraries have limited liability in cases where there is a conflict can really help to ensure that libraries feel comfortable operating within the bounds of the Act, and that they aren't so risk averse that they're even afraid to do what the Act meant for them to be able to do, which I think can very much be a problem here in New Zealand sometimes.
Yeah, and I think, to be fair, the Act has tried to do that. It's given some exemptions and said, yes, you can recompense the copyright owner if they turn up, but I think that needs to be extended, because there are other areas where there are things where there's probably reasonably low risk, and it would be better to do it and then deal with the consequences a bit later. Yeah.
Any other questions? Excellent. In that case, I will thank you all for coming. Come to the next webinar. We're going to be having these throughout the period where the submissions are being worked on, and we really look forward to working with all of you guys. And don't hesitate to send emails, both to the Standing Committee on Copyright and also to me. If you have any questions for me, we are more than happy to help you. Like that's what we're here for, is to make sure that you feel supported in this process. So thank you all.
Thank you.